Mr. Winjum, you may proceed.
May it please the Court. Your Honor, this matter involves the issue of whether the tragic events of 4/29 of 2011 constitute one accident or two under an automobile liability policy. The facts are set out in the briefs, but essentially Marlon Just, my client, was traveling southbound on Highway 5 in Warren County. It's a 4-lane road, 2 lanes going southbound, and a vehicle driven by John Crivero comes across going the wrong direction. A terrible accident occurs. Mr. Crivero pays the ultimate price, and my client goes on down the road 200, 300 feet, pulls over, turns on his hazard lights, and stops, calls 911. Sometime later, Travis Hughes is riding his motorcycle southbound, and he sees the stopped semi-truck with its hazard lights on, and continues on and ultimately comes upon the vehicle that Mr. Crivero had been driving. It was across the roadway. He's unable to stop, and a second collision occurs. Injuries are terrible. Mr. Hughes loses his leg below the knee. Mr. Just has significant medical bills, and essentially we have 2 lawsuits that were filed against the estate of Mr. Crivero. Ultimately, the question arose as to whether or not this involved 2 accidents. And the reason that came up is because there's a farmer's policy that defines the scope of coverage as related to how many accidents there were. And a declaratory judgment action was filed, and the district court ultimately determined that this was 1 accident as opposed to 2. It's our position that the court essentially put the cart before the horse. Essentially, we have language in the policy that limits liability for all damages for bodily injury resulting from any 1 accident, and there's some limiting language that follows that says that this is the most we will pay regardless of the number of insureds, claims made, vehicles or premiums shown, or vehicles involved in the auto accident. So what we believe is the district court did was it decided, I mean, this language assumes there's only 1 accident. What it should have done was it should have gone through and said, well, really, how many accidents
What bearing does our law that we have comparative fault now, and fault's sort of a combination of negligence and proximate cause. I mean, it's not just one or the other. I mean, do we have to look at the basis of liability before we could answer the question as to whether or not it's 1 or 2 accidents?
I don't think so, Your Honor. Basically, what we do is we always look at, the cardinal rule is to look at what do the terms of the policy say. And in this case, the policy says is determined by how many accidents there were, period.
If your argument, it would seem to me that if there was a 87-car pileup, we're in L.A. now, we're not in Des Moines, Iowa, but an 87-car pileup where the first person spins out negligently and then 86 people run into each other, we have 86 accidents or 87 accidents.
Well, I don't think that's my argument, Justice Wiggins. I believe, and as you go in and you look at my reply brief, we looked at this Shepkovitz case, which applies this cause theory that the appellees are arguing. And I think the things you look at are whether there was a single force involved in this car pileup, this 25, that is a continuation or a continuing situation. That would probably be 1 accident.
You're saying, let's say, instead of in this hypothetical what happened here, if Mr. Just's truck had just collided with the SUV and stopped there, and then the motorcycle had come along and hit the truck, that would be 2 accidents?
I think that's a much closer question, Your Honor, and I think there are cases that kind of go all over. I mean, I think that in this case we have a passage of time and a completely different force.
But as I read the record, the passage is seconds, and nobody disputes that. It's not minutes, it's not hours, it's seconds.
It appears to be seconds, yes.
And getting to the policy language, I understand your point, but we do construe policies as a whole, so don't we have to give some meaning to this phrase regardless of the number of vehicles involved in the auto accident? And the district court made the observation, I don't think it maybe originated there, maybe it came from that Georgia case, that language really only makes sense if you can have multi-vehicle accidents, that is, more than one impact in an accident, because you're not going to have 3, 4, 5 vehicles collide at exactly the same time.
Correct, and I think the court, in a footnote, talked about the simultaneous, that this would be meaningless because you can't have simultaneous accidents. But I think a more appropriate way to look at this is, again, looking at the cases that have, if the court were to adopt this cause theory, for example, and superficially it appears that that's a majority rule in chain reaction accidents. But this Shepkowitz case is a situation where you had a car semi accident and then later on a car semi accident with that same semi, and that court basically identified what it looked to, Illinois law, whether there's a single force and an unbroken or uninterrupted continuum of events. A later case, Monroe, had a situation where a semi hit another semi and continued on and had a fiery crash with another semi. That was a continual situation. Here we have a situation where you have an accident, which could stand alone as an accident, followed by a passage of time, a new force, which by itself could stand as an accident.
Did you have a new act of negligence? I mean, my problem is that you have, and I'm not even getting to the cause part, but you have insurance companies who underwrite insurance policies, and they underwrite risks based on negligent acts of a person, and they want to pay X amount of dollars for a negligent act, and I think Justice Mansfield talked about multiple cars, 10 cars, 100 cars, 1 car, whatever. I mean, what were the separate acts of negligence that would distinguish these two accidents?
Your Honor, I don't believe the question has to do with acts of negligence. The question of acts of negligence is already addressed in the policy as far as its definition of coverage. And if you look at page 7 of my brief, I cite the language, "We will pay damages for bodily injury or property damage for which any insured becomes legally responsible because of an accident." So you have two different inquiries there. So the issue as to acts of negligence, legally responsible, go to that. The Austin court here has identified, when we look at the issue of accident, it's identified it as a misfortune with concomitant damage to a victim and not the negligence which eventually results in that misfortune. And what I'm basically arguing, Your Honors, is the insurance company chose the language. It did not define accident. It did not define accident as an accident involving negligence. It said how many accidents. And we're talking again.
But an accident in the insurance world has some fault and causation, because we all know that if it really was an accident and no one caused the darn thing, insurance companies never pay. So if it's truly an accident under that definition, they never pay. If you're going to take that, I mean, I think, I used to argue these cases, and the defense would say it's just an accident, it's no one's fault, and I think you're giving too broad of a thing of accident when you look at the history of insurance law and how these terms have been defined over the years.
Well, I think, Your Honor, and again, I think we're talking about scope of coverage rather than whether there's coverage. We know that there was an accident. There were 2 accidents. And we also know that there's also potentially legal liability for both of them. And both of these accidents could stand alone. But we're talking about scope of coverage as to accidents that we know already exist. Again, I would refer back to the language that the policy has, where it defines what kinds of things it covers. Things that are, there's legal liability.
Counsel, going back, following up on Justice Wiggins' question, the alleged breaches of duty might not necessarily be exactly the same as between Mr. Just's case against Crevaro and the motorcyclist's claim, right? I mean, isn't it possible, at least, that the cyclist's claim against Crevaro is based on the allegation that Crevaro's vehicle was blocking a lane of travel after the previous crash, and that there was a breach of the obligation not to have your vehicle on the roadway in that location at that particular time?
That could be a basis, yes.
Crevaro was killed on the first impact.
Yes.
Which distinguishes this from that Illinois case, right? Because that one, there was a collision, and then the negligent driver, the insured, moved the vehicle but didn't move it off the road sufficiently.
It may, Your Honor. I would argue again that the focus on the act of the party is not the driving force in these cases. Rather, and again, we look at more of an objective, as Austin recognized, and also the Liberty Mutual versus Pella case. Again, we're talking about what is an accident. It's not who caused the accident, what was, is there legal liability because of the accident. The legal liability issue is contained in the policy. It's a separate inquiry.
Counsel, was it conclusively determined that Mr. Crevaro died as a result of the first impact?
I have no knowledge otherwise. I believe that's what the report indicated.
All right.
But I don't know. At least that's what the police report seemed to indicate.
Ejected from the vehicle, is that right?
I believe that's correct. Yes. One thing I would point out is that this Maddie case ultimately is the one that the trial court relied on, the Appellees did. Ultimately, that was a summary judgment was made at the federal level after the certified question was answered, and the motion was denied. It was sent to a jury. The jury decided there were 2 accidents in that case, and the 11th Circuit affirmed that. The motion for summary judgment is 719 Fed Sup 2nd 1377. Jury decision 2010 Westlaw 5463088, and then there was an 11th Circuit affirmance of that. So even this Maddie case illustrates that there can be 2 accidents even under these rules that the Appellee would like us to adopt. I think the appropriate way to approach this is simply look at the policy itself. And again, the policy does not define the term accident. We look at it from a common sense point of view, and this policy does not say how many accidents caused by negligence. It's not a question of whether or not there was an accident like we had in the Peterson case, and we get into issues of viewpoint and so forth. This is a question of how many accidents. It's a scope of coverage rather than how many, or I'm sorry, as opposed to whether or not there's coverage.
Is it your contention that the policy language is ambiguous?
I think that it could be seen as ambiguous, and obviously we know the rule it relates to ambiguity in these kinds of contracts. I think that if one were to look at, we have 2 collisions, 2 separate forces, 2 causes, the best way to read that would be 2 accidents. And again, each of these accidents could stand on their own as accidents. If say, Mr. Crevaro had just spun out of control, didn't have the truck accident, but was in the middle of the road, boom, you have another accident. To me, it is clear and not ambiguous that there's 2 accidents based on how the policy reads. I also would argue, though, obviously, that any question or ambiguity that exists should be construed against the insurer. I would also note there's a number of cases that are cited by the Appellee, and most of those can be distinguished. Many of them involve a vehicle driven by a plaintiff hit twice in the course of events, wants to make two claims. We're not talking about one plaintiff with two claims of accidents. We're talking about two separate plaintiffs. There's also a number of them where you do have these chain reaction accidents. And again, I think as these two cases from Illinois demonstrate, if you have a situation with a separate force and an unbroken or uninterrupted, or I'm sorry, a broken or interrupted continuum of events, that's when you have two accidents. I would add one more thing. I see my time is about up. Even the cause theory matters deal with those kinds of issues, and in this case we have a separation of events, and I believe we have two accidents under the terms of the policy, and no matter what approach you use, you come up with that same result. So I see my time is up. I thank you for your time.
Thank you as well, Counsel. Mr. Anderson.
Thank you, Your Honor. If it pleases the court, Kermit Anderson here today for the defendant Appellee, Farmers Automobile Insurance Association, also known as Pekin Insurance. I think the question in essence here is, how do you construe and interpret the word accident for purposes of this policy? I mean, we've got a policy that my client issued to Mr. Crivaro that has a limit of $500,000 for each accident, quote unquote. The policy goes on to say, and I think this is important, and all the other cases that have, courts that have been faced with this issue think this language is important. It goes on to say that this is the maximum for all damages for bodily injury resulting from any one auto accident, regardless of the number of claims made or vehicles involved in the auto accident. So clearly the policy contemplates a multi-vehicle collision incident can constitute a single accident. There's no question about that.
I understand your argument, and I understand your opponent's argument, but is there not, even if we adopt your legal interpretation, is there not a jury question as to whether or not there is a separate accident under the definition of the policy?
Oh, I don't think so, Your Honor. The facts in this case, I think, are undisputed. This was decided on cross motions for summary judgment. I don't think the parties, any of us, raised any sort of a disputed fact issue. It's just a question of how the word accident is to be construed and interpreted under the undisputed facts. I know some cases like the Oregon case, and apparently, I hadn't realized this, but I assume it's true, that the Maddie case went on and there was a jury determination on the point. But here the facts are undisputed. I mean, it's clear what happened.
Well, see about a case that I found that was decided recently. If you're not familiar with it, we'll move on. But Itzkowitz by the Second Circuit decided September 15th, 2015. Because it's one of these
Second Circuit case, Your Honor, you say?
Second Circuit. It's one of these chain of events cases, and it is different in the sense that New York follows what they call the unfortunate event test. I don't know what that is. It sounds like something out of Lemony Snicket or something. But it does seem factually not all that different. In that case, there was a dump truck that I guess it was too high. It hit the overpass, and the box fell off the truck. And then two cars successively collided with the box, and the court said that was multiple accidents, not one accident.
And were they construing the identical language that we have here?
It's pretty similar. It does have the thing about regardless, although they don't talk about it, which maybe diminishes the persuasiveness of the case.
And there is such a volume of case law and case authorities that have addressed this same issue. Did that court distinguish all these other various cases, Maddie and all the rest of them?
They followed unfortunate events.
Unfortunate events. Well, my position, I'm urging the court to adopt the cause theory, which seems, from my research, to be the universal rule. That's
Well, I think you make a good point here, but we've kind of struggled with this this issue in the context of criminal law, and how many crimes are committed within a single type incident. And when we try to unravel all of that, we identify multiple of factors to consider, and the insurance policy in this case, to me, seems to identify just two factors: the number of vehicles and the number of claims. Is that? And
well, that's what the language says.
Yeah, but if you were interested in limiting your policy to the facts of this type of case, why don't you include more factors within the policy language to guide us and to guide everyone in how the accident concept is going to be limited?
Oh, I suppose they could have done that, perhaps, but of course we're left with the language as it is. And
so
how do you effectuate language that clearly contemplates multi-vehicle collisions as
Right.
constituting one accident? How do you do that? And my point is that the courts, virtually every court to be faced with this question, has decided that issue based on this cause theory, and they're saying that it depends on how many causative acts are involved in resulting damages or injuries.
Pretty standard. My sense is from doing the research, this is pretty standard policy language. It's used around the country by multiple different insurers. Is that
Well, that's
fair?
that's my understanding, and in fact, if you look at a lot of the cases that I've cited in our brief, I mean, the language is identical in many cases. The Maddie case, for example, the language is identical. And if it's not identical, it's not materially different, shall we say. I did want to say, I mean, so the question is, how do you effectuate this language that contemplates the multi-vehicle collisions? The cause approach is what all courts have developed. You apply the cause approach here, and it's clear that there's just one accident. Mr. Crivero, of course, it's undisputed, was killed on impact. The cases, virtually all the cases, the Sepkowitz case, this Miller case from Ohio's intermediate court, they have virtually all found multiple accidents where the driver regained control and went on to commit another act of negligence. And the courts have analyzed that and said that's an intervening second act of negligence, therefore two accidents. Here, obviously, that didn't happen. But all of the cases, the Sepkowitz case is the one that the appellant is relying pretty heavily on, but there's a lot of distinguishing factors there. For one thing, those two incidents were 5 minutes apart. Now, my point is not that time is the bottom line factor here, but time is a factor to consider, certainly. And that is something that distinguishes that case from this. It's 5 minutes apart. You've got a driver who was sitting there in his semi after the first impact. He does nothing. He doesn't pull his semi forward. He could have. And he regained control. And then a second accident 5 minutes after the first. So obviously you've got a second, and the circumstances had changed that had a bearing on the second accident. So clearly you have two discrete acts of negligence, therefore two accidents. And that's how all the courts have viewed this, and we simply don't have this here. I think what the plaintiffs are really arguing for is essentially an effects test. How many effects do we have? I mean, we have two effects, obviously, because we have two injured parties. And in fact, the plaintiffs, appellants, don't even argue for a second intervening act of negligence. They don't even make that argument. So query what sort of standard or rule are the plaintiffs arguing for here? And it's my conclusion that it's an effects test. And clearly that can't be the governing rule because it's so arbitrary. For example, the language clearly contemplates that multi-vehicle collisions can constitute one accident. So what kind of time separation is going to be allowable? Plaintiffs would argue here, I guess, that mere seconds is too much, and that means 2 accidents. Well, there are cases that have found 1 accident where the separation is a minute and a half. So if mere seconds is too much, how much is tolerable? A microsecond? I mean, how do you possibly administer a test like that? And there's not one case that I've found anywhere that applies an effects test, such as the one that I submit is being urged by the plaintiffs. It just isn't workable. Back to the Sepkowitz case, I've said that it's distinguishable. There are separate acts of negligence. The collisions were 5 minutes apart. The driver retained control. And one thing that the court in the Sepkowitz case said that I think is applicable here, and that is, the court said, this is not a situation where after the initial impact, one vehicle immediately ricochets off the other and within seconds collides with a third. Well, that's exactly what happened here. And in Sepkowitz, the court there said that's what distinguishes that case from these other cases. Here we have Mr. Crivero hitting the Just semi-trailer. It ricochets off, lands in the middle of the highway, and seconds later, there's a second collision. That's exactly what happened. And so even under the Sepkowitz case and its analysis, I think that court would find 1 accident in this case. One point on the interpretation of the word accident. The plaintiffs seem to want to apply the definition that a lot of liability policies use about an unfortunate or sudden event and so on. They want to apply a definition of accident from another context to this context, and I submit you can't do that. And in fact, this court, in a case that I've cited in my brief, I only have the name of the first party, Central Bearings. It's in 179 Northwest 2nd, I believe. But there the court said, and I think this is appropriate to this case, it said that the word accident itself can't have an all-inclusive definition and should be interpreted within the context of the document in which it is used. I mean, I think that's a very apropos statement to consider in this case. You need to interpret and construe the word accident in the context of this insurance policy, which clearly contemplates multi-vehicle, non-simultaneous events can constitute an accident.
Also, some insurance policies, I think more general commercial liability policies, use the language continuous exposure to conditions or repeated conditions. Would that have made a difference here?
Oh, I don't really think so, Your Honor. In fact, you know, as I've argued in my brief, there's many courts that have faced this issue with the word accident defined, undefined actually, in any way specifically. I don't think it would make any difference, frankly, because that kind of a definition I submit is the sort of definition that should be given to accident, even when the term is not specifically otherwise defined in the policy. Because how else do you effectuate the language about multi-vehicle events constituting accidents. I think the trial court got it right here. The trial court found one accident, and I urge that the trial court be affirmed.
And is it your position that when you read the policy as a whole, in both accident and then the additional language about number of vehicles, that it is not ambiguous?
Correct. No, I don't think it's ambiguous at all. And I would just add to that there's pronouncements from this court throughout Northwest Second to say that just because a word is undefined doesn't mean that it's ambiguous, and just because parties may differ on the meaning or interpretation of a word, that also doesn't mean that it's ambiguous. So I submit it is unambiguous. So, thank you very much.
Thank you as well, counsel. Rebuttal argument?
The question came up as to what we are asking the court to apply, or how we were asked what rules and so forth, and we would urge that the court look at the policy, and that is where we begin. And I think the Miller case, which I haven't discussed, is right on point for this way of looking at it. In this case, there was nothing in the policy that talked about a continuing exposure to the same kinds of conditions. Miller looked at that and said, hey, that makes a difference. And the Maddie decision, the dissent was very strong on that point too. Let's look at contract language. Let's not read into the policy. Let's not put
You're resting your argument on what an accident is. But as I read the policy, it says any one auto accident. So what does the phrase any one add to your, or subtract from your accident argument?
Well, I think what, again, we're getting, I think, the cart before the horse. The first question that has to be answered is how many accidents were there? And of course, if you have accident A involving Crivero and the semi, and accident B involving Crivero and the motorcycle, one accident is going to be subsumed by all of the requirements that go to that one, and then the other one the same. And I think it's what we have here is, my belief is that we had some circular reasoning in putting the cart before the horse, assuming...
Tell me how you'd write this policy if the insurance company wanted to do what Mr. Winjum says they wanted to do. What language would you use?
Well, I think, first of all, the policy, as it's written, takes care of most of these chain reaction situations, because we're talking about one continuous event, as the Illinois cases have shown. But this is a completely different situation. And
how would you write the policy to take care of the situation?
Well, I think one easy way to do it would be an accident includes, or what we see in occurrence policies. An occurrence is an accident which includes the exposure to the same or similar events. And that might do it, at least according to the Miller court.
To apply that here, I saw that in your brief, but that seems like kind of odd language to apply in a vehicle accident context.
Well, I would point out, Your Honor, the Zurich case, which is that Indiana case that was decided with an attempt to apply Iowa law, involved a semi that hit 8 separate vehicles, and it did have that language. And the court, if you look at the end of its opinion, discusses that, and that was a large part of how it came out.
But how about to this case? How would that language? How would you kind of reason through that language here?
Well, I think what a policy could read: continued exposure to the same or similar conditions, or it could have said accident caused by the negligence or a negligent act of the insured. It did not do that. Again, that's kind of goes to the whole point. It decided accident kind of in a vacuum, and now they're asking us to put all these conditions on it where it doesn't exist in the policy. If it said we only pay for accidents involving, or if there's a number of vehicles and only one negligent act, you could put that language. It'd be very easy. So we don't have that here.
And I get the continuous exposure, that might work in the situation where you sort of have a car being driven negligently down the road and it sort of hits one car after another in succession.
Right.
But here where you had a car that was driven negligently in the wrong side of the road and there's purely one single act of negligence here that resulted in 2 injuries.
Yeah, it appears that that's the case, Your Honor. However, I don't think the term accident as defined in the policy or in the cases, that has any relevance as written. And I guess as the court has asked already, you know, if we were to put that into the policy, the insurance company could certainly do that. It did not. And I think maybe perhaps the court's, this Inskowitz case might be instructive in that. It's clearly not that simple that, you know, we base things on causation and negligence. The Austin case talks about that. The term is accident.
I've been reading the policy, and accidents used all throughout the policy for all different reasons and for all different coverages. But it seems to me consistent throughout the policy, it's referring to one incident that causes them to pay money, because they have it in the uninsured motorist case, they have it in the collision case, you know, where it's your fault, and things like that. So, I mean, when I look at the policy as a whole, I mean, it doesn't seem to support your argument. Am I missing something?
Well, I would disagree, Your Honor. I see my time is up, but I think, again, we're talking about scope of coverage rather than is there coverage. And those accidents, like again, in Peterson and all these other cases, those issues come up. This is a separate thing. I would go by the terms of the policy, and I believe the courts that have looked at this look at these force issues, continuing situations, as opposed to chain reaction accidents. And I believe that the insurance company could have written the language. It shows the language. So that's all I have. Thank you very much for your time.
Thank you as well, counsel. The case then is submitted, and I'll let the students leave the courtroom. Thank you again for being here, and then we'll hear the arguments in the next case.